Hello, everyone, and welcome to the AI webinar series organized by the technology and data team at European law firm Fieldfisher. Today, we will focus on the contractual considerations for AI system procurement and implementation. My name is Tim van Kanet, and I'm a partner in the technology and data team in Brussels, Belgium. And I'm joined by my wonderful colleagues, Katharina Weimer from our German Munich office, and by Louis van der Dongt, associate in our Brussels team. This webinar is the fifth installment already in our series. In the first four webinars, we have covered topics such as generative AI, high-risk AI systems, and AI governance. If you missed these, I invite you to head to the Fieldfisher Data and Privacy channel on YouTube, where you can find recordings in our AI playlist. In the coming weeks, we will organize two more AI webinars, one about the role of the DPO and the AI officer and whether it should be one and the same person, and one that looks at how you can leverage DPIAs in the context of AI risk assessments. Before handing over to Katharina, one last practical point. If you have questions, feel free to write them down in the questions box, which you should find in the control panel, and we will answer them at the end of the webinar.
Thank you very much, Tim. So as Tim just mentioned, we're talking about contractual considerations for our AI system. And this is our overview of what we're going to talk about today. So first of all, we're going to look at what is an AI system, and Tim will explain to us why it is different from normal software systems and other things you have used so far. Louis will then go on to explain to us AI-specific contractual considerations, and I will give you a deep dive on some of the typical clauses and give you some highlights on what you have to take into consideration when you're contracting for AI. Next slide, please, Louis. Thank you. Now, with the AI system, I'm pretty sure you have all read the definition in Article 3. It's a machine-based system designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives from the input it receives, how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. We all know by now that this is a very wide definition and has been cause for a lot of discussion. It's not a really easy assessment to make, and we hope that the European Commission will shortly issue guidelines that will help us in better understanding this definition when you're looking at the systems and the softwares that you're looking at deploying. And I'm asking my colleague Tim now to give us a bit more detail on why it is different from the next slide onward.
Yes, thank you, Katharina. So indeed, why is it different from, let's say, regular software or IT contracting? Well, there's actually two reasons. And the first one is linked to the way in which AI systems are created as opposed to classic software. Classic software development is a relatively straightforward process, actually. The customer, typically it will start with a customer who defines some requirements that they have for a certain IT system. The supplier will then translate that into specifications, which are then converted into detailed designs. And it's based on these designs that the supplier will build, i.e. code the system. And once the system is built, it will be followed by a series of tests and acceptance, and ultimately the system will be deployed. Now, classic software, and that's obviously the huge difference, classic software is operating based on a rule-based logic. If you put it very simply, what it means is that if a user performs a given action, the software will execute a pre-programmed action. So what it means is that if the code is written correctly and the tests were successful, there should be no surprises. And in classic IT contracting and software development, there are two main models to develop them. And you can see on this slide, first on the left, you see the waterfall or V model, which is a model that adopts a Big Bang approach. The entire system is designed, built, and tested, and then put in production as a whole. It's a very structured and predictable way of working, but I would say the key risk with this model is the fact that you only find out at the end of the process if the entire system is working. And then, as you can imagine, it's often difficult to adjust the dial. Also, in the context of the waterfall or V model, there is quite little interaction between the customer and the supplier during the entire build process. So from a customer perspective, it is a bit of a black box. On the right hand, you can see a depiction of the so-called agile approach, which tries to tackle these two issues that are inherent to the waterfall or V model. Agile adopts a quite radically different approach. It's one of incremental delivery and team collaboration. You don't build the entire system in one go. Instead, you deliver functionalities in small increments. And in the agile lingo, these are called sprints. So instead of one big go live, you have multiple launches at the end of each sprint. And so it allows you to adjust more quickly to problems or even evolving customer needs. Now, if we go on the next slide, you will see that the development of AI systems is more akin to the agile way of working. Especially for systems based on machine learning, the development is not a linear process like waterfall, but one with many feedback loops. And there are typically 4 phases, and especially phase 1 is very different. During this first phase, the model will be designed and built, obviously, we'll say. But that first phase contains an important activity which consists of collecting and also cleansing, processing the data. And that's the data that is then used to train the model. The results of the training will likely not immediately generate the anticipated results. So in practice, the developer will need to adjust the designs and the training data set several times. And so you will have multiple iterations during that initial phase. After that phase, obviously the model must be validated, which means that a different validation data set will be used on the model. Depending on the results of these validations, it may be needed to go back to phase 1 and to make more or less substantial changes to the model. And then, if all goes well, you go to phase 3, where the AI system will be deployed, following which it will need to be monitored in the live environment. And if during this last phase problems arise, issues surface, well, you may need to revert to one or more of the previous phases to address these problems. And so on the next slide, you will see that all this means that AI system development is quite different from classic software development. It's inherently an iterative process of really trial and error. And because it is quite difficult to verify the operation of an AI model, and that's certainly true if you're dealing with complex neural networks, well, there the margin of errors will often be higher than is the case with classic software. And needless to say, the accuracy of the AI system will heavily depend on the quality of the training data, which is therefore a crucial stage in the process. So all this means that suppliers of AI systems are struggling, and that's our experience. They're struggling or they're reluctant to offer the same level of performance guarantees that you normally find in a classic IT contract. And so your AI contract will need to reflect this different reality compared to classic software. If we go to the next slides, you will see that another reason why AI contracting is complex is because of the complex value chain. With traditional software, you often have 2 parties, the software provider and the customer. Or potentially in certain cases, you will have 3, the software provider, an integrator, and the customer. But as you can see on this slide, in the world of AI, you often do not have just one provider. In fact, many AI system providers rely on systems that are created by providers of general purpose AI systems. And they themselves rely on providers of tools, components, and so on. So it means that the end product that will be commercialized is often the result of the work of several providers. And so if we then look at who commercializes these AI systems, well, there as well, you see that you may have different parties. Obviously, there are the providers themselves, but you may also encounter distributors or importers, so commercial intermediaries that are tasked by the providers to commercialize their products on the market. And there are also the product manufacturers who integrate AI systems into their tangible products. And so from a customer perspective, the deployer, you are not necessarily contracting with the actual developer. And that's an important thing to bear in mind. On the next slide, you will see that in practice, in many cases, you will or may end up with a long chain of parties. And more importantly, perhaps you will end up with a contract at each point in this chain. And as a result of that, especially for the parties that are somewhere in the middle of this chain, it is crucial that all these contracts are aligned. So, for instance, if an AI provider is accepting certain obligations vis-a-vis the deployer, well, that AI provider must ensure that these obligations are not at odds with the right it has in its contract with the downstream or upstream rather GP AI model provider. So having a good back-to-back coverage is crucial, but as you probably all know, it's often easier said than done. Now, the AI Act states that the AI Office may publish model clauses. This is one of the possibilities. A lot of people are hoping that these will be published. At this stage, it's unclear whether that will be the case, but what is certain is that it would certainly simplify the contracting discussions if these kind of model contract clauses would be published. And then finally, on the next slide, one last thing that you need to bear in mind in terms of why it is different is the fact that your approach to AI contracting will also differ depending on the contracting scenario that you're in. Buying a license for an off-the-shelf AI system is probably the most common scenario. So on the left, that contract will typically be a simple adhesion contract. Well, the contract itself may not be simple, but it will simply be an adhesion contract. So as a customer, you will have little negotiation margin. But on the other hand, in those instances, the system should be more mature and therefore the risk should be lower. If you buy a system that needs integrating or tailoring, fine-tuning, well, then the contracting part will obviously become more complex. You will need to address different risks and issues, such as interoperability with your other IT systems and so on. And then finally, if a customer is asking a provider to build an AI system from scratch, well, then the customer will probably have the biggest margin of negotiation. But in itself, the scenario is the most risky as you're creating a system from scratch. And so the contract will normally be more complex and you will need to detail certain clauses, certain topics, which will not necessarily be included in the first scenario that you find on the left on this slide. So in conclusion, it's important to know which contracting scenario you're dealing with to be able to properly identify and address your contractual risks. And with that, I hand back over.
Thank you, Tim. So I will walk you through some important contractual considerations that are specific to the creation of AI systems. So really talking about that build scenario. What are the things that you need to think of in your contract with a supplier when it comes to building an AI system? We'll have a look at the importance of the intended purpose of your AI system, how to set requirements and specifications for an AI system, and then we'll have a look at some of the regulatory requirements for high-risk AI systems and how some of those should actually be considered for any type of AI system. So let's begin with the intended purpose. The intended purpose of your AI system is a starting point for many of your regulatory considerations under the AI Act, but it also has many contractual repercussions. As a company, you've defined a certain problem and find that an AI system is well suited to solve that problem. The intended purpose of the AI system is then to solve the problem that you've defined. For example, you want more accurate weather predictions, or you want to do a prior screening of incoming CVs to get a short list of the most promising candidates. What you need to consider from a regulatory standpoint and also in your contract will depend greatly on that intended purpose. For the first use case, the weather prediction model, discrimination and bias might not really be an issue. But for a CV scanning tool, that's a point you may want to address in your contract, for example, by including tailored requirements and warranties. The intended purpose of your AI system will dictate how accurate your AI system should be, whether your AI system falls under a high risk category, whether it's appropriate to implement logging requirements, what your requirements are in terms of data quality, and so forth. Having a clear view of what your intended purpose of the AI system is really paramount. It helps you understand your regulatory obligations, your contractual considerations, and it also speaks to your subsequent governance considerations. But today we're talking about contracts. So how is the intended purpose reflected in your contract? A first avenue is through the instructions of use. Under the AI Act, the provider must draw up these instructions of use, which determine what the AI system can do, what the AI system cannot do, and what you shouldn't be doing with the AI system. The instructions of use must be comprehensible and accessible, and should take into account the needs and foreseeable knowledge of the target deployers. Now, this is quite important. Imagine, for example, that your instructions of use are not comprehensible and the AI system causes damage. Well, in that case, the deployer could argue that it was not clear to him or her what the system could do or what the system could not do. Practically speaking, the provider may want to have deployers acknowledge that they have read and understood the instructions of use. Also, every action that is outside of the intended use could arguably not be attributed to the provider. So therefore, how the intended use is circumscribed really has legal implications. The provider will want to have it very narrowly circumscribed, whereas a customer may want to push for a broader interpretation and take into account, for example, the promotional materials and statements that have been made by the provider. So you can see how these instructions of use are a really legally significant document. And these instructions, the provider also needs to factor in the reasonably foreseeable misuse. This is the type of human behavior that is predictable in light of the context, the specific characteristics, and use of the particular AI system. If foreseeable misuse can lead to health or safety risks or risks to fundamental rights, this should be included in the instructions for use provided by the provider. Well, what then with unforeseeable uses? Considering the novelty of some of these AI systems, the chances are that there will be unforeseeable and unintended consequences of your AI system. So how do you cater for that risk? Well, to address this, the parties should make sure to put in place measures to detect, report, and rectify unintended consequences arising from the system's operation. Well, depending on the circumstances, this can mean that you have to incorporate a reporting obligation in the contract for the customer that is deploying the AI system. Now, a key issue to get right in contracting for AI systems is how to define the scope of those systems. A risk for AI contracts is that in the excitement and optimism at the start of the deal, parties don't invest enough effort and time in understanding and documenting what they're buying if they're the customer, or understanding and documenting the customer's desires and expectations if you're talking from the supplier's perspective. In the IT contracting world, the requirements are a high-level description of what the customer wants to buy. This is what you would often find in the request for proposal. For example, the customer asks for a car with 4 wheels. Now, in a regular software contracting setting, the provider will translate these requirements into very detailed specifications. How fast can the car drive? How much horsepower does it have? What's the size of the wheels, etc. The provider will then ask the customer to sign off on the specification, and that way you can easily check off whether the output, the result that has been created, meets the agreed upon specifications. If that is the case, the parties then proceed to acceptance of the solution and payment, a transfer of risk, and start of the warranty period. Now, here's the catch. For standard software, you can chart beforehand what the system will look like. For AI systems, that's not necessarily the case. As Tim explained with the iterative AI system development, you cannot define a fixed set of specifications at the outset. They evolve over time as new data becomes available and as the model learns from its mistakes. So how do you objectively determine what you delivered is what the customer ordered? In these circumstances, instead of using detailed specifications, you define success as objective and measurable outcomes. For example, if you're building a recommendation system, the customer requirement might be to improve user engagement. Instead of specifying exactly how the system should achieve this, you could express it as a measurable outcome. For instance, increasing click-through rates by 20%. So the message here is to invest time and attention upfront to define what success looks like. And this will help avoid discussions later on. So the next question is then, what are the specific requirements and specifications that you need for your AI system? In the previous sessions of the Fieldfisher AI webinar series, our colleagues looked into the requirements for high-risk AI systems, and you can see them listed here on the slide. Now, of course, not every AI system is high risk under the AI Act, and these requirements may not always be relevant for you from a regulatory point of view. That said, we would argue that these requirements can in fact be relevant for any type of AI system from a contractual point of view. That's because these requirements are derived from the high-level expert group ethics guidelines for trustworthy AI. If your system complies with these requirements, it can be deemed trustworthy. It goes without saying that as a customer, you want to buy an AI system that can be considered trustworthy. As such, these requirements reflect best practice, and therefore it can be a reasonable contractual demand that the AI system you're buying is aligned with these requirements. For example, as a customer, you will want to obtain that the AI system you're buying is accurate, robust, and cyber secure. Now, to push this point even further, it's worth noting that each of the high-risk obligations has been incorporated in the standard contractual clauses for the procurement of AI by public organizations. Now, this is a document coming from EU institutions, and you can find the link in the notes to the slide deck that will be shared after this presentation. And it's a very useful reference if you need to start drafting a contract from scratch. Now, we won't go into all of the requirements here, but just highlight a few for your considerations, starting with accuracy. How accurate the output of your system needs to be will depend on the intended purpose. I talked about how you measure success. Well, this is a classical example. You need to think well about how you want to define accuracy. For example, if you're dealing with a system that detects whether parking tickets have been paid, a false negative is not the end of the world. A false negative would mean that even though someone paid the parking fee, the system falsely registered it as unpaid and the person in question gets a parking fine. It's not fun, but it's not the end of the world either. On the other hand, if you're dealing with a medical imaging scanning tool that detects cancer on MRIs, having a false negative can have fatal consequences. So you really need to think about how you want to define accuracy for your AI system. What you need in terms of accuracy will also depend on the output of your AI system and how that output impacts its environment. Is the output of the AI system merely a prediction, or is it a recommendation? Or further even, is it a decision? Is there a human involved that checks that decision? All of these factors will impact what you need in terms of accuracy. Now, all this to say, accuracy requires due deliberation and thoughtful drafting in your contract. Another requirement worth exploring is transparency and explainability. There's multiple aspects to the concept of transparency and explainability under the AI Act. Transparency means that the AI systems are developed and used in a way that allows appropriate traceability and explainability. They should not be made needlessly complex. In this respect, explainability is then about understanding how the system came up with a specific output. At the same time, transparency is also about being clear about the capabilities and limitations of the AI system. So this ties to the intended purpose and instructions for use I was talking about earlier. And finally, it's an obligation vis-a-vis the affected persons. People should know that they interact with an AI system and they should be informed about their rights. Now, how to fill in these requirements will again depend heavily on the AI system. If the requirements do apply fully to your AI system, this can have contractual repercussions. For example, if you're a deployer and you are required to be transparent towards an affected person, you may want to have technical measures incorporated to help you understand how the AI system reaches a certain output based on the specific input. You'll want to incorporate this in the contract. In some circumstances, you may also want to consider incorporating logging obligations in the contract, where you keep a log trail that helps trace back the AI's decision to specific data inputs and processing steps. And in some cases, you may consider incorporating obligations on the provider to give you information that you need vis-a-vis the end user. And then a final point for me is data quality. This is a very important one. You've all heard the maxim garbage in, garbage out. In machine learning-based AI systems, the algorithm derives rules based on training data with certain statistical properties and then tries to apply it to unknown data with potentially slightly different statistical properties. What data you use as input for the algorithm and the qualities and properties of that data is decisive for the quality of the output that you get. In a contractual setting, that means that you need to include some requirements for your training data. Is your data set complete and accurate? Does the data describe the phenomenon that you want to have investigated? The data that is collected has to be the right proxy for the live data that you want to use the AI system for. Another important question, who is providing the data? Is it the provider or the deployer? And are you allowed to use the data? Is it personal data? Is it protected by intellectual property rights or confidentiality obligations? Now, the IP part is something that Katarina will look into in a few minutes. It's also important to know that you cannot simply plug your data set into an algorithm and start training the system. Quite often, there are some prior steps needed to prepare your data for training. You may need to annotate it, label it, enrich the data, aggregate it. This is something that you may need to factor into the scope of your contract. If you're a vendor and your customer is the one providing the data set, you may want to include some assumptions as to what the training data set is supposed to measure and represent. This will allow you to rescope if the training data does not meet the assumptions, and additional preparatory steps are needed to vet the data for training. Also, what happens if the training data set is not sufficient because it's not representative or if there are other issues? You may need to have a process in place to manage gaps in the training data. So as you can see, there's a lot of elements you need to consider in your contract as it pertains to building your AI system. But once it's built, the next question is how the AI system performs and how you should address this in your contract. And for that point, I hand back over to Tim.
Thank you, Louis. Yeah, so indeed, once your system is deployed, you will need to monitor its performance. And in a way, you can think of this as the sort of maintenance phase that you may know from classic IT contracts. So it means that you will need specific clauses that deal with incident and problem reporting and management. That in itself is really not very different from classic IT contracts. And because of the time restrictions with this webinar, we won't cover this here. But there are, however, on the next slide, some contractual considerations in relation to input data. So the data that end users will input into the AI system once it has been deployed. Part of the topic around input data is really linked to the intended use that Louis was already referring to. So from a supplier point of view, it will be important to contractually define which input data may or must not be used. Suppliers should therefore consider adding a clause which prohibits the use of certain data. For instance, if in terms of risk management measures, the system is not designed to process sensitive data, well, then ideally there should be a clear prohibition in the contract for the customer to use that kind of input data. In addition, it may be helpful to exclude performance warranties from a supplier perspective for input data that the AI system was not intended to work with. Because if it hasn't been trained on that kind of data, then as a supplier, you don't know how the system will react to that input data. And there are also some contractual considerations from the customer perspective in relation to input data. If the input data contains personal data, well, then obviously those familiar with GDPR will know that the customer will want to obtain contractual guarantees around the processing of that personal data to make sure that it happens in accordance with the GDPR. More specifically, I would say in the context of reuse, it will be important to specify whether the provider may reuse the input data to further improve the AI system. It's something that many, if not most, providers will ask. As a customer, it will be your call, obviously depending on your margin of negotiation, to answer yes or no to that question. But if you do allow the reuse, then you will need to define contractually which conditions the supplier must comply with. And obviously the focus here will be around ensuring that your confidential information is not breached, and that in relation to personal data, there are proper anonymization or at least pseudonymization techniques being implemented. If we go to the next slide, there is, I would say more generally, the fact that the quality of the AI system's performance must be contractually dealt with. Louis already talked about this important question, what does good performance look like? From a provider's perspective, you will likely actually want to add an obligation for the deployer, i.e. the customer, to have a human in the loop to verify the output. They should not blindly rely on the output, and in certain use cases, because of the AI Act, it will even be required to have a human in the loop. But by default, it may be good to contractually oblige this on the deployer. And from a customer's perspective, you can ask for a performance warranty of some kind. For instance, in the context of an off-the-shelf system, you will likely see in the contract a quite basic performance warranty, and you can find an example clause on the slide. Now, you will probably agree with me that the example on the slide is quite vague. It's difficult to measure. And so what does it really mean to you? Which comfort does it give you as a customer if your supplier is committing to these kind of warranties? There might be a lot of discussion in terms of what's appropriate is, right? And so if we move to the next slide, what you really want as a customer is, or what you should probably consider, is to include an SLA which will quantify what good performance looks like. SLAs are obviously often used in IT contracts. I've put two examples here on the slide in blue. In the context of hosting, it's an availability SLA, which is standard. In the context of maintenance, you will typically see SLAs that deal with the incident resolution times. Well, these SLAs are typically measured on a monthly basis, and if they are not met, they will trigger service credits. They will, or they may trigger, again, depending on margin of negotiation. So the service credits, which is nothing less than a monetary penalty, is something that the provider then owes to the customer. So in the context of AI, it might be useful to consider having SLAs that deal with some of the specific challenges, whether that is around bias avoidance, about output accuracy, etc. Of course, whether your contracting counterpart will accept them will depend on the contracting scenario and your margin of negotiation, but it is definitely a useful exercise to help you manage your risks and understand what you consider to be an appropriate level of performance. I will now hand over to Katarina, who will do a deep dive on some typical clauses.
Thank you, Tim. And I think you and Louis have already prepared the ground quite well for what I'm going to discuss in the next few minutes. This is an overview of the clauses that often trigger a lot of negotiation in the contract, and so they should, in particular with regard to AI contracting, because as we saw in the examples and in the information that Tim and Louis provided, these are the topics that cause most concern and where you really need to be very mindful of your intended purpose, of the performance parameters, what you're expecting from your AI software, and also what you expect as an output and what could happen if that output goes wrong. Before we go into those clauses, though, which are typically warranty, liability, indemnity, I want to briefly give you an overview of the intellectual property that is often part of the AI world, and that we stress that you should consider when you're looking at either procuring or providing AI software. There are certain IP assets that are involved here, and we've put some of them here on this slide that might be protected by intellectual property rights or that you want to have protected. So for instance, looking at the training data, if you're the party that is providing the training data, you may need to provide a license to the supplier of the software, and you also need to be sure that your training data is clean, that, as Tim has mentioned before, the personal data is being logged into, and also whether you want that training data benefit anyone else than yourself. On the other side, if the supplier provides the training data, the customer then needs to obtain a proper license to use that as well in light of the AI system. And again, for this license and all for the other IP rights, which I'm going to mention, it is crucial that you think about the scope of the license that you're looking at. What kind of rights do you need in order to use that AI system? Another crucial IP asset is, of course, the source code of the AI system. That is naturally protected. But what's more interesting is the adapted AI system following learning, and on the bottom left, the learnings by the AI system while in use by the customer. All of these are developments that occur during the use of the software. And these can be protected by, for instance, copyright, and they might contain trade secrets of either of the parties. There are also certain database rights that may come into existence, and all of these need to be taken into consideration. This is particularly relevant when we're also looking at the customization of the AI system into your system. Whether that triggers any particular rights or whether you require specific protection. And then once it's integrated, you include that basically into your trade secret portfolio, this specific customization of the AI system. On the other end of the scale, there is the AI system output. And I think that has already triggered so many discussions, because the copyright protection of an AI system output is basically not there, because copyright protection exists for human works. So you need to consider how you want to protect any output by your AI system, especially if it's generative AI that produces texts, images, and similar. And if you need those protected, you have to think about it very well, because copyright protection will likely not be there unless you involve a human being actively working on that system output. Then again, of course, you have the documentation that is involved in this entire project, which is that in itself is subject to copyright protection, and the training instructions may also be. I think the outcome or the main important takeaway from this slide is there are quite a few aspects within the AI system or AI software that will be protected, but the protection differs, and you need to be very wary of that and mindful when you're looking at your procurement or when you provide the software. On the next slide, I've basically put this together in a summary. I want you to consider the required rights and permissions to use the data, copyright, database rights, and trade secrets. These are the ones that are the most important ones and that you will have to deal with. And then again, the license scope is crucial. What are you allowed to do? What are you allowing the other party to do? Do you want the data to be available to the supplier or not? That is what Tim mentioned before, whatever your margin is, but also, do you want to enable them to continue developing the product? There is an example on the right-hand side for licenses, but it's quite generic, and I think you will have to be more specific than that when you're looking into this. There is also on the next slide a brief discussion of open source software. It's quite prominent in the open source, in the AI community. Especially like we all know that, of course, OpenAI was an open software at the beginning until it had to start making money. There's different types of licenses. It doesn't always mean that open source is free, but you have to be very mindful if and when it is being used of the type of license, open source license that is being involved. So please be mindful of that. Now, as the next topic is something that both Louis and Tim have already alluded to, is the warranties, and those very strongly depend on what you've agreed as specifications, as performance, as required output. If you've determined what is failure of the software and how is it supposed to work, the SLAs always are a crucial factor in determining your warranties or when the warranty rights are triggered. Now, of course, there's the general differentiation between express and implied warranties. Implied warranties are unwritten promises that arise from the nature of the transaction and the assumed understanding by the buyer, which was to be expected by the supplier. There is usually an implied warranty of merchantability, of course, and a fitness for a particular purpose, if that purpose was known to the supplier of the software. So if both parties communicate about what that software is supposed to be doing, what the expectation is, and what purpose it is supposed to achieve, remember your intended purpose from the beginning. Do discuss it, do be open about it with your supplier, because that will help in defining the warranties and the scope of the warranties. There are express warranties as well. These are the ones that you expressly agree upon with your supplier, or if you are the supplier, you want to be sure that in the express warranties you include the limitations, what you cannot warrant, which typically in AI software always depend on the data input, on the limitation of the purposes of the customer. And so with the warranties as well, these have to be very tailored to your specific AI software project. It's worth investing time and effort into the thought process on warranties and the negotiation on warranties. Some countries also have statutory warranties. There are national laws. For instance, in Belgium, a specialized salesman cannot exclude warranty for hidden defects. In Germany, as an example, goods have to be fit for the usual purpose of contracts of this type. As we've learned until now, the usual purpose will be difficult to determine in AI software. So again, the strong recommendation that you think about your purpose and that you include it in the discussions. If the warranty case comes up, you will have to think about the remedies, or you hopefully have thought about them before and included them in the contract. As an ultima ratio, there's termination of the contract, but you've probably already put a lot of effort into all of this, so maybe you don't want to terminate. Hopefully you can repair the software. And this also goes back to Tim's initial explanation of how you may have to go back to the earlier phases of your AI software development and deployment and revisit some of these. A replacement is a much bigger task already, which you're likely going to want to avoid. And then, of course, damages. Damages in case of triggered warranty claims will also be at stake for you. On the next page, there are some typical warranties that you want to consider. Please, both parties have to be realistic in what they expect and what they request as a warranty. I won't go through all of these in detail for timing purposes, but if, as an example, the supplier will hardly be able to warrant compliance with all applicable laws at this stage. It might not be able to warrant accuracy, provenance, and so on of all the training data, depending on where it comes from. And on the other hand, the customer might not be able to warrant that it will not use the AI for a high-risk purpose. You just might not know this at the outset. You want to, and these are the requests that will usually come, but be considerate. You have to be mindful of who has control over what aspects. And also be mindful that there's still a lot of development, regulatory development in this space. Leaving the warranties, I want to move on to the next slide for another big topic always in these contracts, which is liability for damages. In an II context, it's closely related, of course, to the performance of the software, which Tim had elaborated upon, and also to the warranty claims. Now, first, there is statutory liability and there's contractual liability. I've put the differentiation up here on the slide. Liability for defective products, goods, that ties into the warranty as well. You have to be able to determine when the software is faulty or defective. So that goes into the specifications, the intended purpose, the expectations that you've outlined together as parties, so that you have a clear picture of when the product is defective, and also think about what kind of damages or liability it can actually cause. The contractual liability, in contrast, is for violation of the contract it's basically for breach of a contract. You want to the general part, the general thought here is, where does the AI output become erroneous? Where can it lead to specific harms? As an example, it creates financial advice, or it gives output that you use for financial advice and it was incorrect. Mistakes can lead to real life harm for people, or the example that Louis brought up, where we're looking at medical scan AI software that then results in faulty results. You have to be able to allocate liability for these types of mistakes. And it is crucial that both parties understand their exposure here. On the next slide, I'm giving you a bit of an insight into the contractual liability. Now, this slide is quite busy, and as I understand, you will be provided with the slides afterwards, so you can go through this at your leisure. On the right-hand side, I think, are the most important points. You want a clear and comprehensive allocation of responsibility, and that requires you to do your thinking. You want to think through what can go wrong, and what does this going wrong cause, or what are the potential consequences? And then what are potential reliefs for that? How can you address that? On the left-hand side, you see that there are some causes of system failure once you've defined what failure is. It could be based on system design, on training data, on human oversight, and all of these various causes for liability should be considered in the contract and should be allocated to each of the parties. As you see in the brackets, the causator, or the party responsible for that cause, differs, and it can even be either party for bad implementation. As we know with software projects, if and when they go wrong, they usually go mightily wrong. And it helps to have this, to have given a lot of thought to these liability clauses beforehand. Especially as a supplier, you want to consider your liability caps. And as a customer, you need to be sure that you can accept these liability caps. As an example, if there is a chatbot that you use for AI, and the chatbot was only one of these small features you have on your product website, but this chatbot gives incorrect answers. And it's, for instance, a medical website, or a technical product website. And now, because of the chatbot's incorrect answers, the product is being used in an incorrect way. The consequences might be huge, but usually the liability for incorrect answers of one of these tiny chatbots the liability is capped at, say, 10,000 per case. That's not going to help you much. So you have to think through the entire chain of what's happening there. Next slide, please. Another clause often triggering lots of discussion is the indemnity clause. The outset of the indemnity clause is a different one than the liability and the warranty, but it also goes towards coverage. Indemnity usually deals with a situation where a third party has certain IP rights and doesn't go after the provider or after the original supplier, but goes after the customer who, in using the AI software, is possibly violating third-party rights. That is your traditional case. In that case, of course, you want the provider, the supplier of the AI software, to indemnify you against those third-party claims. Again, though, when you look at the second bullet point here, there has to be a mechanism to allocate the risk, and that has to be quite granular. Where does the IP infringement really come from? Does it come from the original data set, and who has provided the data set? Does it come from the application? Does it come from publishing output that should not have been published? Where is actually the liability for this third party right violation? You want to, so that clause, which already triggers many discussions in normal cases, will have to be revisited in more detail for AI software projects and be even more tailored to the specific project. It can make sense to have or it can turn into a de facto insurance policy if there are broad indemnity obligations, but I doubt that suppliers will lean into that. But we will have to wait and see. That depends on the negotiation power, I guess, and on the trust that they place into their systems. This was a deep dive into some of the clauses. I'm now asking Tim to provide your takeaways to you with the next slide and the key lessons, and I hope you will be taking these on board with you.
Thank you, Katharina. Well, I will be quite brief because I see we have a couple of questions that we would like to address as well. But I think by way of conclusion, I think it will be clear, or at least we hope it will be clear, that there is no one size fits all from a contractual point of view. What needs covering in your contract will really depend on the use case. And I think it's also important to acknowledge that the lawyer who needs to draft this contract cannot do it alone. It's, I would say, as with anything in AI, it will be important to involve all the relevant stakeholders within the organization to ensure that the contractual provisions are aligned with the operational needs and the way of working. And then finally, and I think that is the positive thing, if you're familiar with classic IT contracting, you will find that you can apply a lot of the classic concepts that you are familiar with to an AI contract, but there are clearly certain aspects that you will have to address a bit differently, certain risks that are not relevant or non-existing in the context of a classic IT contract. And I think I'll leave it at that. Let's see at the questions. If you still have questions, feel free to write them in the question box. And yeah, Katharina, I think you.
Yes, I'm the question moderator. Thank you, Tim. So let's briefly get to the first questions. Will the slides be attached and dispatched? I think they will be. As far as I know, that's what we've been told beforehand. The second question, I think that is for Louis. Are the instructions for use mandatory for all types of AI systems?
Indeed. In fact, they are not. This is an obligation that is placed on providers of high-risk AI systems. So speaking purely from a regulatory perspective, the answer is no.
Yeah, indeed. And I would perhaps just add that even if it's not mandatory from a legal point of view, I think it's certainly something that we would recommend from a risk management point of view, actually for both parties involved. Being clear on the intended use will protect the supplier. It will avoid that unintended use may trigger the responsibility of the supplier, so that, for instance, a non-high risk system suddenly would become one. but it also protects the customer in the sense that you want to be sure if you buy something that you will be able to use the system for the use that you have in mind. And so having clarity about that in the contracts may be very helpful.
Thank you. Sorry, my question box just, here we go. Do you see SLAs being implemented for large language models as well? Assume that providers may likely push back due to difficulties in valuation of LLMs and inconsistent industry benchmarks, and how could a deployer might mitigate this?
Yeah,
SLAs for LLMs.
Yes, it's a very good question. I think so. At this stage, what we're seeing, if you look at some of the bigger players in that area, they are offering some SLAs, but they are, I would say, more the sort of classic types of SLAs in terms of the system being available. I believe Microsoft for Copilot is offering an SLA in terms of response rates. If you ask a question to Copilot, in how many percentage of the cases will you get an actual response? I'm not, to be very open, I don't think any of these big players at the moment is offering specific SLAs in terms of accuracy or being bias free. And I think today it will likely be very difficult to get that into your contract. I know I said it's certainly good to consider it, and I would certainly encourage you to try, but most suppliers will try to push back on this. And I think with the current state of these technologies, I think as a customer, to some extent, you need to accept that you won't be able to get a perfect protection from a contractual point of view, and that you will also need to address these kind of risks at an operational level by, for instance, including a human in the loop, by not blindly following or trusting the outputs of these models.
Thank you. Beyond the contractual liability, is there a general legal liability for AI systems foreseen by the AI Act? Who wants to take this? I don't think there's a general legal liability for AI systems, which is specific to AI systems in the AI Act. Not that I'm aware of.
Indeed, so we do have the liability AI liability directive, and there's also some tweaks being worked on in the general product liability directive, which would focus on this strict liability, so the extra contractual or tort mechanism. But that it's not part of the AI Act, and as far as we know, at this stage, the AI liability directive, unlike the AI Act, hasn't been fully come to fruition. So it will not be adopted, or will likely not be adopted at the same time as the AI Act. But it is something that the EU is working on and that they are planning to implement.
Thank you. In instances of embedded AI, rather than procuring AI solutions, do you see clients starting to include AI disclosure clauses, and what differences would you see panning out? I'm not quite sure I understand the question.
I think I do understand it. So we have come across a few instances where actually it wasn't clear to a party, an organization, that some of the solutions they were using did include an AI system. They were procuring a product or a system, and one of the features within that quite big product or system was a limited AI system. I think it is obviously very important, and I think much like we've seen with open source software, a lot of IT contracts include an obligation on the IT provider to disclose if they are planning to use any open source software. I think from a customer's perspective, it's certainly something to consider, to include a similar disclosure clause in the contract, whereby the provider has the obligation to inform the customer that its products or services may rely or have AI embedded in it. Yeah, absolutely.
Thank you. Will the recording of the session be provided as well? It will be available on the YouTube channel that Tim alluded to at the beginning, so you can always refer to that. It's the Fieldfisher Tech and Data YouTube channel, where you can find this session and the others. Am I correct, Tim, or did I say something wrong?
Yes, absolutely, absolutely.
Okay.
Just looking at the time, I see we've run out of time. I think if we just can go to the next slides, if you are looking for more, obviously, well, feel free to contact either one of us. If we didn't manage to answer all the questions, sorry about that, but drop us an email. We'll be happy to respond to them. You can also find more information, and for instance, our AI regulatory guidebook on our website, and you will get the links when you receive the slides. We hope you found this webinar interesting, and obviously if you haven't already, do sign up for our next webinar about the DPO and the AI officer, which will take place on the 4th of June at 5 p.m. Central European Summer Time. Thanks a lot for listening in, and let's stay in touch. Thank you.